Hi, everyone. Thank you so much for joining us today. My name is Lauren Grahowski. I'm the editor-in-chief of the Virginia Journal of Law and Technology, and we are super excited to present a symposium on chilling effects. I'm going to hand it over to Professor Citron, who will introduce the event.
This is such a terrific gathering. Thank you so much, Lauren, for and Bridget for making this happen. There is nothing better than writing an email. I had just had John's manuscript in my hands and read it over the summer. And I emailed Lauren about the book and said, "You've got to read this. It would be, a terrific to feature in a symposium." And Lauren, thank you so much for your enthusiasm, for making sure everybody John and I wanted here to be here. Not that we had to strong arm you. What an incredible group of people. But Lauren, you did and Bridget did a fabulous job putting this all together. So I just get the honor of introducing Dr. Penney, our wonderful colleague, and the author of this brilliant book, Chilling Effects. I feel like I want to say Chilling Effects, Repression, Conformity, and Power in the Digital Age. Dr. Penney is an associate professor and the York Research Chair in Artificial Intelligence, Data Governance, and the Law at Osgood Hall Law School of York University in Canada. And he keeps his sort of incredible friendship uh, and working relationships with so many organizations because that he's touched and he remains in close touch with. So Berkman Klein at Harvard Law School and the Citizen Lab at University of Toronto and Cornell's Department of Education, sorry, of Communications, they all get to enjoy having John as like a research fellow, an associate. So he keeps his fingers, his intellectual fingers in all these pots all the time. When John was getting his doctorate at Oxford, this group here, we were all at the Privacy Law Scholars Conference in June of 2013 when the Snowden revelations dropped. And little do we know or realize that John was in, I love this explanation, John, in the book, that you were in your little apartment in Cambridge and you thought this is going to be a seismic event. It's going to help us figure out the extent to which public-private surveillance, totalizing surveillance, has an impact on how we behave, and the sort of, as you would call it, productive power. That was your hypothesis. And as Professor Neil Richards had said to me when we were first talking about your work, he's like, "We finally found the person to prove everything that we've been theorizing the impact of surveillance to be." And John, you've helped us make it real and helped us theorize how we think about the conformity role in chilling effects and effects themselves far beyond law, right? In the way that we have public and private surveillance. And so you're a gift. And it's always wonderful to see. Of course, we returned to Privacy Law Scholars Conference when we got to meet. And also, we've got to honor your work there with the Reidenberg Kerr Award for your research and in 2020. And having you as a colleague on the advisory board of the Cyber Civil Rights Initiative has been a joy. And the coup de grace for me has been so meaningful as getting the chance to work with you through a grant that we got through the Knight Institute. We were able to study the way in which law, content moderation, the practice of companies, and the impact on the way in which people were targeted with online abuse, how law could actually enable them and help them to speak and to engage and not to conform. So, John, thank you so much for that work with Alexis and I. It has been a real, what do they say, career highlight. So I'll stop making you blush. I hope you're not angry at me, John. Dr. Penny, I'm gonna now pass it over to you so you can talk about your book. And I'm going to, of course, stay on and listen to all of my incredible colleagues. So thank you so much. Thank you, everyone, for participating. It's so meaningful to us at the University of Virginia and VJOLT. So thank you. John, here we go, friend.
Thank you so much, Danielle. And really, I mean, I can't think of a better, person and mentor and colleague and friend to introduce this work for all the reasons that you mentioned, given our work together, given the background to the research, but also everything, as I've noted in the acknowledgments in the book, how much you've taught me as a scholar, and how you as a person not only are a leading thinker and really deeply influenced my work, but you also, as an example, bringing up the scholars around you. I think my work is an example of that. You've supported my work, supported my vision for the book, and you were there from the beginning, and now at the end, I guess not the end, maybe the beginning of the book, as it were. So thank you so much for that, Danielle. Lovely invitation. Of course, I will also have many profuse thanks for Lauren and Bridget, but I'll get to that later to the closing. Thank you so much. So let me first share my screen. Great. And so I'll start off in just providing, a little bit of context to the book. There's the cover for those who haven't bought it yet. I expect everyone to go out, eventually and get it. The book, as Daniel introduced, is Chilling Effects, Repression, Conformity, and Power in the Digital Age. And I'm just absolutely delighted to have this opportunity to speak to all of you. Of course, at the outset, I need to thank the Virginia Journal of Law and Technology, Lauren and Bridget, who have just been phenomenal, as Daniel mentioned, in organizing, planning, and coordinating this. None of this would have been possible. Of course, now hosting it today, I cannot thank them enough. And of course, I'll thank them again at the conclusion. But in addition to my home at Osgood Hall Law School, where I teach in Toronto, there's a few additional institutions that Danielle had mentioned, the University of Toronto Citizen Lab and Harvard's Berkman Klein Center for Internet and Society. Really, the book itself and the research underlying it would not have been possible without the support over many years of these institutions. So I'm quite thankful to the people there and many who I see on this Zoom as well today. So it's great to see them, people like Adam Holland and others. So it's great to see all these people, and I'll continue. So I want to talk about sort of some of the background to this concept of chilling effects. Of course, this notion of chilling effects, if you've not encountered it, really has a dual nature. It's both a legal concept. It emerged within American jurisprudence, First Amendment law, but it also is a concept that refers to a behavioral phenomenon. That is a behavioral tendency for us in the face of threats, like threats of surveillance, legal threats, threats of violence or harassment, how those kinds of threats, in the face of them, they have a chilling or discouraging effect on our behavior. That is, in the face of these threats, we're less likely to speak freely, to engage freely, and exercise our fundamental rights and freedoms. And today, those threats are increasingly being weaponized against us to chill, repress, and manipulate us. And we're not ready. And the reason that we're not ready is that the way that we think about this threat, the way we think about chilling effects in law, public policy, and research has been deeply flawed. And part of what I advance in the book, one of my key motivations in the book, is to advance a new understanding of chilling effects and a roadmap for how we can effectively respond. But of course, the other context to why I wrote this book and why this matters today is the context that we're living, right? We today live with ubiquitous surveillance devices that we carry around with us. We collect data about who we are, what we like, who we connect with, where we are, constantly, all the time, and are transferring to a plethora of third parties who themselves are using and profiting off of that data and shape our own behavior. We live in the post-Snowden world, where we're now aware that governments in the United States and around the world and across the West, we know, are engaging in persistent online and offline mass forms of surveillance for national security reasons. But we also live in an era of surveillance capitalism, where companies like Cambridge Analytica collect data about us, not just to profit off of us, but also to manipulate us as well. And those kinds of processes also have important chilling and shaping effects on our behavior. But we live also in a new technological era, right? With new forms of facial recognition technology, bodily recognition technology, new forms of surveillance above us and in our homes. And of course, these technologies had led to a whole new breed of companies, right? Companies like Clearview AI, which the New York Times in 2017 said might be the company that ends privacy itself. A company that misappropriated billions of facial images to train its AI machine learning algorithm that it combines AI power with facial recognition technology for a service that's it's now marketing to law enforcement and security agencies around the world, including security agencies with not just spotty human rights records, the worst that you can think of. But it's not just companies, it's not just government, it's also abusers. Like the story of Rachel Feldman, who I talk about in the book, who was a victim of a relentless online harassment and stalking campaign coordinated on 4chan, which forced her to leave not only her writing, but she stopped publicizing her work for fear that her co-authors and co-editors and co-contributors might also be victimized by the same abusers and stalkers. Or the story of Coles Whalen, a musician in Colorado who was a victim of an online stalking and harassment campaign that forced her not only out of her home, but chilled her life so much that she also abandoned her life's passion, her musical career. But of course, I couldn't speak about the context of chilling effects today without speaking about the Trump administration. Because really, in my view, the Trump administration represents a whole new era of this threat and public policy challenge. Because we're talking about not just governments or companies taking action for national security reasons, or even for surveillance capitalism. It's an example where these threats are being weaponized to chill dissent, political opposition, democratic mobilization, and to victimize disfavored groups. And this is done to allow the administration more freedom and impunity to carry out its public administration. Whether we're talking about foreign students being snatched off the streets in a sleepy suburban suburbs of Boston, like Tufts students Rumeysa Öztürk, who simply authored one article exercising her First Amendment speech and was detained under threat of deportment by plainclothes ICE agents in the middle of day. Or, of course, DOJ prosecutors threatening protesters at Tesla retail locations around the company. Or threats against law firms that had a track record of holding the Trump administration accountable during the first Trump administration. Or universities, too, have been key points in the first Trump administration criticizing and analyzing the administration's goals, have also been targeted with threats. Essentially, any institution within government and outside of government that had a track record of holding the government accountable has been targeted. And of course, today we see the spectacle of highly visible militarized presence on cities across the United States with random acts of violence, which of course have a profound chilling effect. But it's not just those kinds of actions in day-to-day life. There's, of course, a unique synthesis within the Trump era of state and tech power, and companies like Palantir are at the vanguard of that new synthesis. You hear talk and threats to protesters and observers of federal actors across the country, like ICE, threats that protesters are being entered into mass databases and being labeled terrorists. Well, companies like Palantir are the heart of those efforts, which themselves have a clear and intentional chilling effects. People will often look around and think about the effect and wonder, are chilling effects trivial? And I think even today we can look around ourselves and see really these kinds of threats work. Because despite having over a year of brutal federal action, brutal ICE tactics, I think protests have been largely muted until at least more recently. You also have law firms that have been threatened who in the first Trump administration brought key lawsuits, have this time refused to take those lawsuits and instead have folded. Universities have bent the knee and decided to change campus rules, change course content, change other kinds of university administration to accommodate Trump administration demands. All of this shows these kinds of threats do work, and we're seeing them work. In fact, people will often remember an essay that Adam Serwer wrote for the first Trump administration, the cruelty is the point. The line that I've been using for the second Trump administration is that the chilling effects are the point. This is an example of chilling effects almost as a consistent government philosophy. They're weaponized to chill critics, dissent, political opposition, so that the government can act more freely and carry out its aims, whether it's war, corruption, or victimizing disfavored groups. And we're not ready. We're not ready because the way, as I mentioned, we think about this public policy challenge is far too limited and deeply flawed. Something I call the conventional understanding, which arrives to us through law. It's too legalistic. It has a very flimsy empirical basis, and it has a very weak explanatory power for all the threats that I've mentioned so far. And it also really cannot explain common occurrences of chilling effects that we on an intuitive level feel and have been documented in research, including my own study that I talk about in the book in the intro, and something that Danielle mentioned in her introduction to the symposium. My study that I conducted following the Snowden revelations in June 2013, where I examined Wikipedia traffic, that is, traffic to privacy-sensitive articles on Wikipedia before and after the Snowden revelations in June 2013, and of course, the widespread media coverage those revelations brought to the public. That is, awareness of the possibility of online or mass online government surveillance. And what I found was compelling evidence of chilling effects, not just in June 2013, but a ongoing chill of people refusing to access information on Wikipedia that continued on for well over a year. Those studies or those findings received a lot of attention. They were publicized in the New York Times, Washington Post, Reuters International, and in The Intercept, amongst many others. And I think because the study actually struck a chord, it resonated with people's concerns about these kinds of mass forms of data collection and surveillance and their impact on our behavior and on our rights and freedoms. But I think they also resonated because we can all on an intuitive level understand that if in a democratic society, for it to be healthy, we need citizens who are willing and able to educate themselves about important matters of public policy, terrorism, and national security. And in what my findings showed is that under threat of surveillance, under threat of these kinds of chilling threats, people were less willing to access that kind of information, none of it legal, just privacy sensitive. And in that kind of era, we're in trouble. And democracy inevitably is going to suffer. And I think that resonated with the public. But what I also found as I dug into my findings that the conventional theories or conventional understanding of chilling effects really could not explain those findings. They also could not explain findings in other areas of social theory and social research as I delved into social science to understand what I was seeing in my own data, in my own empirical findings. For example, like the watching eye effect, a body of literature in social psychology, which finds that where you have people within experiments, when they're engaged in some activity, sometimes it's a game, sometimes it's an exercise in honesty, that when they're made aware that there's a visual cue, that is simply an artificial set of eyes watching what they do, they're more likely to engage in conformity, more likely to be conform with group norms, more likely to engage in pro-social behavior, and to be more cooperative, and less likely to lie and to cheat when it comes to particular games at stake. None of the conventional theories could explain these kinds of conforming effects of observation, nor could they explain other kinds of similar forms of social phenomena, like the Hawthorne effect, which was documented decades ago in the 1920s in a series of experiments at the Hawthorne plant of the Western Electric factories. I talk about this in the book. Those experimenters are studiers who came to the Hawthorne plant aimed to study light fixtures, and what they came away with, this famous impact that they found, that when workers were observed, their behavior shifted. And none of those conventional theories can explain these kinds of observational surveillance effects. And that led me to the new understanding of chill that I advanced in the book, something I call the conformity theory of chilling effects. And what I do is in this book is I draw on this wide, vast body of literature on social influence, conformity, compliance, obedience. And these are some of the key factors: observation, uncertainty, personal threats, and authority and power. And what I found is that these key conformity factors really were chilling effect factors and lined up really well and helped explain scenarios where people often raise concerns about chilling effects and where research had actively documented. Observation being a key impact, explaining the chill of surveillance. Uncertainty, explaining the chill of vague laws and other forms of state and corporate processes. The chill of personal threats, explaining online and offline abuse, stalking, and forms of cyber mobs. And of course, authority and power. The more power and authority the actor has, the greater the compliance, conformity, in the case often in traditional settings, the chilling effects. And what I found in traditional chilling effects scenarios, you have these kinds of powerful actors. And of course, my argument isn't that conformity and chilling effects are exactly the same things, but simply that to understand chilling effects, we have to look to this body of literature. The implications of these findings compared to conventional understanding is that, of course, they have implications for human rights, for speech and freedoms and equality. And I talk about that in the book. But they also have implications for society. That is, chilling effects have both a repressive dimension. That is, we lose speech, we lose activities where people are chilled from acting freely. But it also has a productive side. That is, chilling effects lead to more conforming behavior. It leads to a society that's often more homogenous, less dynamic, less creative, less diverse. But the other reality of this kind of theory and understanding is that if the group norm is actually a norm of tribalism and extremism, that chilling effects and the threats that cause them can also lead to more tribalism and extremism in society. I think we're seeing that as well today. And lastly, why all this all matters is because I think this theory helps us explain why power matters. The reality is that chilling effects have a deeper foundation. The behavioral phenomena that chilling effects refers to has a deeper foundation in psychology and evolutionary psychology. And it means that powerful actors with the sophistication can use them to manipulate us and to chill and repress us. Often we are chilled and we don't even know it. So weaponization is a reality of power, and it's something we have to be realistic to. And of course, lastly, is the future of chilling effects in my view of how to stop it. The future, I think, is something like superveillance, something I coined in the final chapter of the book, where I speak to these kinds of new systems being experimented in China, which combine machine learning, facial recognition, body recognition, and highly personalized forms of enforcement, which are being experimented for years in China, but are now also being deployed across the West, including within the United States. And the future, according to my theory, is a deeply chilling future. So how do we stop it? So in the book, I outline, of course, a better understanding. I argue that skeptics of chilling effects, including amongst judges, lawyers, politicians, and journalists, yes, the skepticism needs to end. Chilling effects are real and their impact are profound on people, groups, and society. And lastly, I set out comprehensive reforms for how we should respond. I don't have time to get into them now, but in the book, and maybe later in our conversation, I'll get into them. So I'll end there, and that's my idea for how we can lead to a far less chilling future. Thank you all, and I'm really looking forward to a wonderful conversation with everyone on the line. Thank you.
Thank you, Professor Penney. So we are going to get into our first panel now. As a quick reminder for the speakers, I will be raising my hand to indicate like you have 1 minute left for your time. So we will hear from 4 professors, and then we will have some time for questions, and then we will move to the second panel. So our first speaker is Professor Julie Cohen. Professor Cohen is a Mark Claster Mamelin Professor of Law and Technology at Georgetown Law. She is a teacher of surveillance, privacy and data protection, intellectual property, information platforms, and her work has been super impactful in every single one of these fields. We are super excited to have you here today. Thank you, Professor Cohen.
Great. Thank you so much for having me. And here it is. So it's a great book. I blurbed it. It's everybody should go out and get a copy. And so as I wondered what I would do with my 10 minutes here, I decided that you know, rather than simply go through the book and say, this is right, and this is right, and this is right, I want to use my 10 minutes for a provocation. So that's what I'm going to do right now. I'm going to share a slide deck here. And so the nature of the provocation is has to do with the question, so what do we do in response to this very learned excavation of all of the ways that that chilling effects can be weaponized and exploited to entrench authoritarianism? Do we conclude from this that that there's no way but the exit, right? And in other words, do we conclude from this that that the answer is to reject all forms of surveillance utterly, because down that road the road leads to ruin. So in other words, what I want to do with my provocation is sort of target this setup in which we see and acknowledge that there don't seem to be any clear stopping points for data collection and processing, and we therefore conclude that surveillance is inevitably tainted. There is no possibility of ethical surveillance or of governing it effectively. On the left side of the previous slide, we have these imperatives, right? Growth, innovation, datafication lead inevitably to the singularity, right? In which we are comprehensively caught all the time in a net of sensors that are used in an automated data-driven way to manipulate us in ways that we can't even yet name. And then on the right side of the previous slide is one inevitable response, right? This is not a future we want. There are thriving movements for surveillance abolition. This is a brilliant paper if you haven't read it. Data capitalism and algorithmic racism. There's there are more kind of pop culture presentations of this argument. But here's the problem, right? Neither side of that slide is exactly right, right? So John, among many things that he eloquently and elegantly does, elegantly restates the case for why privacy is important for human and social flourishing, as have many other speakers on your agenda today. And so my provocation is, yeah, but so is surveillance sometimes important for human and social flourishing. And here's what I want to push John and maybe others to think about. Okay, so when is surveillance sometimes important for human and social flourishing? Well, we've seen one example, which is public health surveillance, necessary in order to enable society to mount an effective response. This is a more controversial one, right? So John has marshaled a bunch of really great and persuasive social science evidence to explain how the conformity effects in homogeneous polarized groups work to ratchet up the horrible cesspool that is visible in many corners of the internet. And yet, right? You also led, even in this presentation today, with the social science evidence in which researchers in labs first realized, hey, people are less likely to cheat and lie and steal when they're being watched. I'm the mother of a young man who I'm very proud of. I think there is a way in which young men in particular are socialized in these groups to behave with conformity effects in these ways. And yes, before we had the cesspools of the internet to socialize young men to behave this way, many young men learned in real world settings to behave this way. However, I do think there is something to be said for the proposition that in real world places, you see less of this. Right. I don't, and I'm just putting that out there. Okay. Then there's this, right? And this is what I'm focusing on a lot in my work currently. So there's all the profoundly antisocial, destructive, existentially planet-endangering shenanigans that the very wealthy get up to when you can't see what they're doing with their money. And at the bottom of the screen, the shenanigans that others predictably get up to when there's an opportunity to steal from people less fortunate than themselves, right? To victimize the already suffering and struggling. So how do we start to think about this in any kind of useful way? It is so tempting to read a beautiful book like Chilling Effects, and I want to underscore it is a beautiful and important book, and conclude, okay, all the signs point in the same direction, right? Nothing good can come of collecting any kind of information about people. I don't think that's what we need to be thinking about. And I wrote a chapter in an obscure edited book that's now finally available after taking like 4 years to be published. And the chapter is called Donut Privacy. You can find it online. But it sort of takes off from this really interesting provocation, which was in the space of environmental economics and urban planning. An author who said, look, there's an epistemological problem within the domain, within the discipline of economics, and it causes everybody to mindlessly line up behind the belief that more is always better and growth always leads to a good place. And what is urgently necessary if we are all to survive, right, is to rethink the space of innovation and economic endeavor in the shape of a donut, in which you need to do enough in terms of growth and productivity and economic development to get yourself out of the donut hole, right, into a social foundation for safe and just space for human flourishing. But if you do too much and you cross the outer boundary of the donut, then we have every disaster that we are now seeing unfold in the skies and the oceans and on the planet. And I think there is something to be said, right, for thinking about surveillance in a similar way, right? You absolutely, so privacy scholars, myself included, right, I'm right there in the club, have written so much about what happens when you cross the surveillance ceiling. And these narratives are very familiar to us. But I don't think we've written enough about the donut hole, right? Public health, tax enforcement is actually really, really important if you want to have any of the other public goods that you want government to provide, anti-corruption, and so on. And so that tees up this question of how to start rethinking about the governance of surveillance when surveillance and surveillance power are sort of embedded infrastructural functions, which is where we are now. And with my like 60 seconds remaining, I'm obviously not going to answer that question for you, but I'm just gonna, well, my animations are terrible too. I'm just gonna pop this last slide up and then conclude. Okay. The we have some governance tools that have been sort of clearly and evidently failing to yield the kind of results that they should be yielding. And it is important to think through particularly the very last thing in the lower right, reversing the power polarities of surveillance system so that they are trained on the powerful and the abuses that they now wreak on the rest of us. Okay, I'm done. Sorry if I went 30 seconds over.
Okay, thank you, Professor Cohen. No, that was great. As a reminder for participants, if you have any questions, please send them in the chat, and we will be moderating that after this panel. Our next professor is Professor Neil Richards. He is the Koch Distinguished Professor in Law and the Director of the Cordell Institute at the Washington University School of Law. Professor Richards is one of the world's leading experts in privacy law, information law, and freedom of expression. Thank you for being with us, Professor Richards.
Thank you, Lauren. You guys can hear me okay? Perfect. So I am delighted, and it's a really great honor to be able to participate in today's symposium that, as we know, celebrates my dear friend John Penney's brilliant new book, Chilling Effects. I think the book is a truly magnificent accomplishment, and it's one that I think brings John, without question, into the company of the finest privacy scholars in the world, a number of whom are here today to no doubt lavish similar praise on the book, which Julie also did, in addition to the really interesting donut provocation. John shows us in a really masterful combination of both of theory, his theory and the theory of others, and empirical work, his empirical work and the empirical work of others, how surveillance can chill expression and belief, and triggering and operating through the social and biological processes of group conformity. So simply, right, John's thesis, which he explained to us a little while ago, is that when we're watched, we conform. And in the digital age, this has some seismic consequences if we want to continue to believe in things like democracy, eccentric individuality, and the development of new and heretical ideas. And I think the best pieces of scholarship are ones that are obviously correct once you hear their argument, even though perhaps no one had actually put it this way before, or no one had realized this before. And the best pieces of scholarship are also ones that revisit old ideas that we thought we understood, but then the scholarship complicates our understandings in ways that drives that understanding forward. And I think John's book does both of these things, which is why, both as a matter of method and of contribution, it's an instant classic, and it's a book that immediately enters the canon of classic early privacy works alongside Hate Crimes in Cyberspace, Configuring the Network Self, Inside the Information Industry, and The Future of the Internet and How to Stop It, to name a few books by some of our speakers today. So I'm delighted to be here to celebrate and talk about John's book and its implications for our field and our societies. And I'm also delighted to be here as I think the only Virginia law alum on the program this afternoon. So wahoo wah as well. So what I want to do today is to talk about some, that's sort of enough praise of the book, as Julie did. I want to talk about some recent technological developments and the ideology that underlies them, and how John's book allows us to deconstruct that ideology and helps us to understand why they're problematic, how the law is failing us, at least, again, if we still care about things like democracy, eccentric individuality, and the development of new and heretical ideas. So there's three things here, right? Ideology first, then tech, then chilling effects. And so my paper's claim and its title is that privacy is not theft. So ideology first. Some of you may have read Dave Eggers' interesting, if slightly heavy-handed 2013 book, The Circle, which was itself made into a middling 2017 movie with Emma Watson and Tom Hanks. And the book might not be 1984, but nonetheless, it has some interesting ideas. Like 1984, The Circle is a dystopian book about a fictional social network, kind of Facebook on steroids, that Eggers uses to say some critical things about corporate digital culture. And this company has, like Google or Meta or OpenAI, a series of corporate mantras that secrets are lies, that sharing is caring, and most importantly for our purposes, that privacy is theft. These mantras are a hyperbolic take on the familiar tone-deaf, solutionist, Silicon Valley tech bro, self-serving magical thinking that we're quite familiar with. But like most good satires, they're rooted in a grain of truth. And it's going to be my claim today, and in the paper that I'm working on for the special issue, that privacy is not theft, and that John's book helps us to see why that is the case in new ways. Now, I'm by no means the first scholar to notice this ideological phenomenon, that the data-hungry engines of informational capitalism view their access to our data as something of a human right, or maybe an inhuman right. Indeed, the idea that they look at human data as a, quote, free asset to be collected, extracted, propertized, and used to create profits and power is a theme in both Julie's excellent book, between truth and power, and also Shoshana Zuboff's surveillance capitalism. But I think some recent developments have brought the notion that privacy is somehow theft more openly into the light, and I think they warrant a response. So that's the ideology. Let's turn to 3 examples of technologies recently in the news that embody this ideology that privacy is theft. The first are Meta's so-called smart glasses, made with Ray-Ban and Oakley, of which they sold 7 million pairs last year. These glasses have subtly integrated lentil-sized cameras in the front, and these cameras can take still and video pictures with audio. So when Mark Zuckerberg just this past week testified in court about Meta's child safety failings, my words, not his, he was flanked by aides wearing these glasses, and the judge had to admonish them not to take pictures of the courtroom. It also came to light this week, Meta has had a busy week on privacy like most weeks, that Meta has decided to add facial recognition to these glasses, which would allow anyone wearing them to identify most people by name just by looking at them. And Meta has justified these tools, at least publicly, as being an accessibility aid to people with face blindness, the very rare inability to recognize faces, or poor vision. But if we know anything about Meta's goals from the past 2 decades, it's their obsession and growth and with normalizing privacy-invasive technologies and business practices to pursue that. So the second example in news reporting this week is that Customs and Border Patrol and ICE are licensing facial recognition technology provided by Clearview AI. And we've already seen masked ICE agents using these scanners to detain people in Minneapolis, notwithstanding the lack of legal process or the high error rates of these tools. And it's worth recalling, as John mentioned in his talk, how Clearview developed this tool through scraping. It was essentially every web page on the internet that had a face and a name associated with it, like the faculty pages of all the faculty participating in this program, social media workers, etc. And I think we've seen more of this also in recent weeks. The backlash to Amazon Ring's ill-fated Super Bowl ad that we just need to tap into a neighborhood-wide surveillance network so that we can save dogs from being lost, even though people tend to find lost dogs, and dogs can often find their way home as a price to be paid for constant and unmonitored surveillance. The third example is one that is directly related to what we're doing right now, which is Zoom AI Companion and Captions. And so in December, just before Christmas, Zoom rolled out a new feature by default to Zoom's video conferencing suite called Zoom AI Companion with Agentic Workflows, which will, as the press release puts it, transform conversations into action. So Zoom executives, apparently lacking any sense of irony or ordinary usage of the English language, parked out that the launch of AI Companion 3.0 is a turning point for Zoom, continuing our transformation from a meeting company into a pioneer of AI-first intelligent work orchestration. By empowering our users with new AI Companion capabilities, we're helping them get even more done so they can focus on connection, said one executive. He went on, offering AI Companion's newest capabilities, both as a standalone option and within paid Zoom plans, reflects our core belief of democratizing access to AI and providing users with intuitive solutions that can seamlessly understand their work context and help move conversations to completion. At the same time, echoing Meta's introduction of Ray-Ban face recognition through the Trojan horse of accessibility, Zoom's LLM is able to offer real-time captions for any user who presses a prominent button. Please don't press the button. And this allows any participant in any meeting to receive a copyable transcript, and you can turn the feature off, but it requires something of a labyrinthine trek through the submenus in Zoom's web settings that makes finding a needle in a haystack seem like the New York Times Games app's most recent fun product. And to bring us full circle, so to speak, to the Meta glasses, the New York Times reports that Meta is also working on glasses internally called super sensing that would continually run cameras and sensors to keep a record of someone's day, similar to how AI note takers summarize video call meetings. So what do these cases have in common? It's the idea that data is necessary to fuel some inevitable narrative of progress, and that depriving progress of its necessary data is some kind of theft. And there's also this new element, one that was explicit in the circle, but implicit in the real world until recently, that it's necessary and virtuous to digitally capture as much human experience as possible in order to move the needle in the direction of progress. And so from this view, it's really unfortunate we can't record everything that happens to us and potentially post it to our socials for likes, engagement, and in some cases, influence or profit. It's also inconvenient not to be able to recognize a face, whether you're at a cocktail party or an ICE agent confronted with an uppity protester. And it's inconvenient and unfortunate that all meetings, classes, client interviews, and patient exams in hospitals don't get recorded, analyzed, and condensed for agentic insights and so-called action items. So this brings me to my third and final point, which is how John's theory of chilling effects as social conformity can help to explain why this is a problem. Put simply, John explains both as theory and a matter of social and biological science why the capture and potential use of all human experience is not an agentic triumph to be celebrated, but is rather a privacy, civil liberties, and democratic nightmare to be resisted. And these technologies become normalized by being pushed out and justified in terms of accessibility and then progress, risking a future which privacy is a bare residuum at best and a theft from our innovation narrative. So worse than John's book helps understand why privacy is not theft. When we are watched, he explains powerful social norms rooted in our evolutionary biology kick in along the axes of observation, uncertainty, personal threats, and power. And the three examples with which I started, I think, illustrate each of these dimensions and the normalization of these technologies, as John explains, that they create a kind of feedback effect with those who have the power, having the ability to reinforce the norms that they want. And so to conclude, this brings us back to democracy and to Meta's glasses. A leaked Meta internal memo said, "The political tumult in the United States is a good timing for the facial recognition features release." They said, and this is a quote, "We will launch during a dynamic political environment where many civil society groups that we would expect to attack us would have their resources focused on other concerns." In this way, I think Penney helps us to see that privacy is not theft. In fact, the real theft is its opposite, the ideology of capture, of collection, of extraction, and of unaccountable so-called permissionless innovation. These activities and the ideology that justify them are the real theft, a theft of individuality, of freedom, and a threat to democracy itself. And it just as it helps to see us, just as John's book helps us to see the phenomenon of chilling effects in a new light, I think his book also helps us to see the dangers that this kind of surveillance poses are dangers to values that we purport to hold dear, of eccentric individuality, of political autonomy, and of democracy itself.
Thank you so much, Professor Richards. That was great. Our next professor is Professor Brenda DeVoskin. She's an associate professor of law at the Washington University School of Law, and she works at the intersection of sexuality and technology, doing critical work on safety, privacy, and consent in online sexual encounters. Thank you for joining us, Professor DeVoskin.
Thank you. Thanks, Danielle and John, for putting this together, and thanks to Lauren and Bridget, especially for making it happen. John's book, similar to what Neil said, I think is really great in taking a concept that many of us thought we understood, chilling effects, and show us that actually we did not understand it nearly well enough. So the book takes an old problem many people have thought about, and that's a conceptual architecture that allows us to make sense of more intuitions and think more systematically about the social determinants and constraints that promote self-expression. I'm also thankful to Danielle for inviting me to the symposium, but also for having created the field of scholarship I often write in. I write about digital abuse, and even when I have disagreed with some of Danielle's prescriptions, I have always been inspired by her leadership in opening up an entire area of scholarly inquiry. And my intervention speaks to both fields. It's about how John's conceptual framework gives us new tools to think about the chilling effects of digital abuse. So one of the most powerful things moves in the book is, I think, John's rejection of the narrow view of chilling effects as simply someone refraining from saying something they otherwise would have said. They would have said something, they were chilled, they didn't say it. Instead, he asks us to see chilling effects as a broader phenomenon of conformity, surveillance, speech regulation, harassment. They do not merely silence discrete utterances, they help constitute the environment within which people form preferences, shape identities, decide what is sayable, doable, livable. So chilling is not just about silencing, it's about the social production of norms. Of course, Going back to what Julie said, a similar point, once we conceptualize chilling this way, we confront the difficult question of distinguishing positive from negative chilling, or if all speech and all behavior shape social norms to which others conform, how do we distinguish problematic chill from ordinary social influence? Jones directs us to look at 4 factors: observation, uncertainty, personal threats, authority, and they help us identify when conformity becomes normatively troubling. In my reading of John's conformity framework, it is the social norms themselves what produce chilling effects. And chilling effects are especially problematic when we face problematic social norms that people feel compelled to conform to. So I want to explore what this reconceptualization might mean for the regulation of online abuse. Traditionally, when we think of online abuse, think revenge porn, deepfake sex videos, unsolicited dick pics, etc. They produce chilling effects in a straightforward way. Someone, usually a woman, receives abuse, she leaves a platform, withdraws from dating apps, prefers safety over pleasure. Maybe she does not receive abuse, but she's aware of its danger. As Robin West says, you only need to be aware that abuse exists to begin preferring safety over your own pleasure. So the phenomenon is real. John's work does not deny it, but his framework helps us see that the picture is more complex. If we care about people expressing themselves freely, we cannot focus only on discrete episodes that frighten someone into silence. We must attend to the broader constellation of practices that produce social norms, especially when those norms are sexist, stigmatizing, and inhibit women's participation in public spaces and sexual life. So chill is not just about what an abuser does to a victim, it's what a culture does to all its members. And if that is true, and I think it is, then law must attend not only to preventing abuse, but also to protecting and enabling countervailing norm production, positive influences on social meaning. Sometimes those 2 goals will align neatly, other times they create difficult trade-offs. So this is how I see it in this specific space, more specifically in some instances of sexual abuse. So take sexual privacy invasions. We know, thanks to the work of Danielle, Marianne Franks, many others, that revenge porn, non-consensual sharing of sexual images can cause serious harm. So their work has offered a path to prevent, discipline privacy violations. That's really important, and John's work helps us see even more. In my view, it explains why it is equally important to offer robust protections for sexual expression. And to be clear, privacy scholarship is very committed to protecting free expression in general. But my point here is that protecting free expression, particularly sexual expression, is not a parallel and important project. Instead, it is essential for changing the social norms that chill women's lives. So, in fact, people do not retreat from sexual self-expression simply because they have a preference for concealment and they might fear that they might lose that preference. They retreat because being seen naked means something, and often not something good. For women in particularly, our nudity can deplete us of value. In a society that regards women as object of consumption, once we're seen naked, we risk becoming seen. Seen is a new status for women that renders us worthless. That meaning of our public nudity is what makes exposure so devastating, and that meaning is what chills. And here is a crucial move. If we care about how people feel pressure to conform to certain norms, we might also care about how those norms might become themselves less oppressive, less chilling. While many forms of discourse can reshape those norms, sexual expression is one of them. And so protecting sexual expression is part of dismantling the very social meanings that made privacy invasion so harmful. Yet, companies often invoke sexual privacy to justify broad bans on nudity. That is, we don't know if the nudity is consensual or not, so just in case we're going to ban all of it. And in the name of protecting victims, they suppress public sexual expression. But if John is right that chilling effects are about conformity and meaning production, then suppressing sexual expression may entrench the very norms that chill, that generate harm. The point is not that sexual expression outweighs privacy. Again, it is that sexual expression is an essential part of alleviating the harms that privacy law seeks to address. So the more complicated the picture, the regulatory picture, is more complicated than we often acknowledge. Another example, similar logics, cyber flashing or dick pics. Women receive unsolicited nude images and experience them as threatening or unpleasant. That experience might shape how they present online, whether they decide to use dating apps or not, perhaps even how they approach intimate or sexual conversations. Turning away from an online space, a dating app, is a conventional chilling effect. But John's account of chilling effects invites us to think about the multiple social determinants that constitute the social norms that people conform to. And here it's worth asking why male nudity offends and female nudity invites. Why is female nudity humiliating for women and male nudity is also humiliating for women? Those meanings constrain people's participation in public life, but they're also unstable and subject to change. Recently, we've seen tons of new cyber flashing statutes in many states, and they now ban the exchange of nude images without prior written consent. That might mitigate some instances of harm, but it is also worth asking if certain practices can reshape the social conventions that make receiving a dick pic dangerous and that force women away from online spaces. With our co-author, Thomas Kadri, a friend of many people here, and I have argued that communities in which nudes are normalized, expected, and understood as an invitation rather than aggression can reshape those meanings and protect women's autonomy and safety. Yet cyber flashing statutes put those communities at risk. They ban the exchange of nudes without prior written consent, even though some communities have consciously adopted diverging norms. Again, John's framework clarifies what is at stake here. If chilling is about conformity under asymmetrical power, then we must ask not only whether a statute prevents harm, but whether it also entrenches the norms that make participation in online spaces dangerous, especially for women and sexual minorities. I think John's book is very productive in moving us away from thinking of chilling effects as isolated, silencing events, and instead it reframes the problem of chilling effects as a struggle over social norms. The shift, I think, is very generative for those of us working on digital abuse. So thank you for the opportunity to talk about the book with all of you.
Thank you so much, Professor DeBoskin. Our final professor on our first panel is Professor Damien Clifford. Professor Clifford is an assistant professor at the London School of Economics Law School, and he is a leading scholar on European data protection, privacy, and the regulation of technology. Thank you for joining us, Professor Clifford.
Thanks, and thanks very much for having me. Congratulations to John on the book. Again, I want to reiterate to everyone that you should go out and buy it immediately if you're not already purchasing it at the moment. What I suppose when I was trying to think about the contribution, I think it's kind of reiterating a lot of what other people have said. I think about my own work when I've looked at chilling effects. It's often, or it's always been really, honestly, in a very passing manner, almost as a byproduct or a symptom of problems of surveillance. So it's brilliant to have this kind of significant contribution that really centers it in a work. He has provided both theoretical grounding and empirical research that provides us, I think, with the tools to really grapple with this issue, but also to explain its significance, I suppose, from a policymaking perspective, but also ultimately as well for the courts when these things are argued. Now, what I would like to do with my time a little bit is maybe because I'm kind of the lone European scholar in the group, is maybe to play the naive believer in EU law and policy, and through that lens maybe offer John the possibility of actually discussing his last chapter or his last substantive chapter before before his conclusion a little bit more. So that chapter entitled "The Future of Chilling Effects and How to Stop It." So, I suppose for all of us who are concerned by the topics that have been raised, what we should we do? And as the random European in the group, and I suppose with my task of being kind of playing this naive believer in the capacity for EU law to do good, I kind of wanted to kind of look at what John suggests, I suppose, as being those kind of things that need to be addressed in order to stop the challenges posed by chilling effects, and to kind of, okay, well, paint a picture of what else could we imagine bar the legislative frameworks that have been devised by the European legislator, yeah, and to offer John, I suppose, the opportunity to expand a little bit more on where he sees the potential weaknesses with those, and also then to kind of invite further conversation on it. So for the benefit of everyone, John outlines, I suppose, four, avenues or things that need to be done in order to stop the emergence, or I suppose the prevalence and the challenges associated with chilling effects. He speaks about the need to restrict surveillance. He speaks about the need to reduce uncertainty, in particular, I suppose, the need for greater transparency, both in terms of the private and public sector uses of technology and data, etc. He speaks about the need to curtail personalization and personal threats. And then he also speaks to questions on the need for to constrain power and authority. And if I was to put on the hat of an EU bureaucrat who was very much a believer in the positive action of EU law, I guess I would be pointing at developments for the last, I suppose, 15 years, I suppose, in terms of EU law restrictions on the uses of data, but also, I suppose, more recently around the emergence of the so-called EU, AI Act, which is effectively a regulation in recent years that aim to do many of these things. So I suppose when we think about restricting surveillance, John does mention, of course, that we've had the EU GDPR. He obviously mentions it and kind of goes through it and obviously highlights some of the significant issues with it. But I guess a true believer in the capacity of a data protection evangelist would say, well, we have an awful lot of the tools that are there in order to restrict surveillance, to find a kind of, I suppose, a balance between the need to protect privacy and also I suppose, the certain circumstances in which surveillance can be in the interest of, I suppose, society as well, to kind of go back at one of the slides that Julie had, I suppose, in the fact that there's a somewhat of a balance between those two things. So, like, I guess I would. I'm suggesting, I suppose, to a certain extent that what do we do, but what we already have, I suppose, in Europe, in that sense, in terms of empowering individuals to make choices, trying to restrict the power of big tech through principles-based regulation, and then, I suppose, more laterally with the development around AI, the AI Act, instituting certain bans of certain technologies. For instance, albeit qualified bans in the context of facial recognition technology, etc. In terms of reducing uncertainty and I suppose requiring greater transparency, you can see that as essentially a byproduct of, or a feature of, many of these regulatory frameworks. And in relation to the curtailing of personalization and personal threats, there are calls now at the European level to have what is being referred to as a Digital Fairness Act, which is essentially going to be part of a consumer law key, which essentially tries to mitigate some of the manipulative impacts of personalization. So, and finally, then, with the constraining of power and authority, we have increasingly, I guess, in Europe, a role for competition law authorities and competition law thinking in regulating big tech, but also, I suppose, with the emergence of a specific regulatory framework, namely the Digital Markets Act. So with all this, I suppose I'm wondering whether John is, suggesting that we all play from the EU legislative rule book and start adopting that as potential solutions to some of the world's problems. Yeah. Obviously, I'm deliberately not pointing out some of the weaknesses. I want to leave that for John. But in terms of the final point that I would kind of like to leave it on then is just the final provocation around what actually amounts to a chilling effect. It was something I suppose that has occurred to me, and when John came and kindly did a presentation here at the LSE, it was something that came up in the conversation that we had here when he presented. But what amounts to a chilling effects versus the genuine regulatory impacts associated with legislation. Any type of regulatory intervention tries to alter behavior in a certain sense. So, like, at what point does something become a chilling effect versus just, I suppose, the desirable byproduct of regulatory intervention? And who decides on that? What value system, I suppose, is embedded within it in order to decide, okay, well, this is the problematic byproduct of surveillance as opposed to the societally beneficial outcome of good regulatory interventions. So I think I will leave it there now, and I look forward to John's responses and the discussion. Thank you.
Thank you so much. I am going to put everyone on like the same screen, and then Professor Penney will do some commentary, and then we'll move on to audience questions.
Great. Thanks so much. So first of all, I want to say, I mean, it's just wonderful to have such eminent, incredible scholars reading your work, taking it seriously, and offering such insightful either provocations in Julie's case, Neil taking the theory in new directions, and the same I could say for Brenda, also offering a really fantastic framing, which I'll come back to in a moment. And of course, Damien, coming from the sort of European perspective, saying, what do you really expect us to do differently, John? Based on what we already did, and I'll come back with some suggestions. And this is a moment where I can offer a reply or comment on some of these great interventions, and then of course we have a period where we'll invite they can reply to me. We'll have a bit of time. We can have some crosstalk, and then we'll open up things to the audience, as Lauren mentioned. So let me start off with Julie, and of course it's fantastic to have Julie here and commenting. I recall when for my session for my paper, Understanding Chilling Effects, which I presented in 2020, Danielle mentioned it. This is a paper that I ended up winning the Reidenberg-Curl Award back at PLSC in 2020. And I recall Julie was the first commentator actually during that session where she opened things up, and similarly said, I can spend some time praising, but let me begin with a provocation where I think things would go in a new direction. And of course, she didn't disappoint then, and she didn't disappoint now. Julie's quite right that there is a reality out there that that many of the processes that I talk about in the book, in particular surveillance, it's not necessarily the case that in all circumstances and in all contexts that surveillance is an inherently negative and bad or even immoral thing. Right? And I think the examples that Julie offered, health surveillance in the context of the pandemic as being sort of a necessary process for effective public health, social surveillance in the context where you have young people in more traditional contexts being raised, where forms of social surveillance may have led to more social, pro-social behavior as opposed to antisocial. And of course, the example she gave for financial surveillance, which can keep an eye on our billionaire class, which these days seem to be increasingly abusive. And my response to Julie is to simply agree with her to this extent. That my theory, I think, in the framework that I offer in terms of the conformity theory, I think it offers both a way of thinking about surveillance such that even in these contexts where there could be positive outcomes, in some cases where you can have excessive forms of health surveillance, financial surveillance, and social surveillance, it can lead to some of the negatives that I talked about. But I think the challenge, of course, as Julie hinted in her message, is that how do we decide? How do we figure out those edge cases? When do we decide good surveillance and more negative surveillance? And I try to offer a framework in the book in chapter 8, a framework for hard cases where I set out some of the factors in the theory, the 4 chilling effect factors, but I also invite drawing on the role of power, thinking about political moral philosophy, and essentially offer a framework for balancing cases where you have competing public policy concerns, where maybe in those cases, like the ones that Julie offered, we justify and we allow surveillance and even allow some of the negative outcomes that I read about in the book if there's an overwhelming public benefit. And I think the framework that I offer there are for some measure, but inevitably think there's more work I also have to do on that count. With Neil's great intervention, I love this because his notion of arguing that privacy isn't theft is a way of turning upside down the discourse that we've been living with of the powerful, of big tech, of big government, and of more powerful, and these days, extremist actors who've dominated the discourse. And we've been living with this assumption that data is there, it's a resource, and it's to be extracted, it's to be used for innovation, and it's to be used today increasingly to manipulate, repress, and repress us. And I love Neil's flipping of that discourse to say what my theory offers as a way of underpinning, and the great examples that he offered. And I couldn't help but laugh a bit at his example of the Zoom AI companion, where they're offering democratizing their platform by bringing in an agentic AI and not understanding how the assumptions that's baked into the innovation discourse, that's baked into the discourse of big tech and of big government, that the data is there and that privacy prevents, right, is a form of theft. And I just love how shifting that discourse and shifting into thinking about and flipping the switch and acknowledging how these powerful actors are abusing that argument or abusing these discourses. And this is a way of sort of fighting back. I also haven't read or watched the middling movie, The Circle, but I'll definitely check it out after this. It's great to do another pop cultural book.
I'm not recommending the movie. I just like the idea, but the movie is less flawed than the ideology it
I see Julie is giving a thumbs down to the movie as well. Brenda as well, who I've learned so much about in her work in terms of sexual norms and intimate privacy. I really loved her framing where she offered right at the end how we need to move from thinking about this threat as sort of isolated, individual chilling effect events to a struggle over norms. And I thought that was powerful and really encapsulated a key part of the work and said it better than how I say it in the book. And really that touches on something that I talk about later in the book about the multifaceted role of law, and something that my work with Danielle, my work with Alexis in recent years has done, where we focused on the multifaceted role of law, to the extent that law, yes, in some contexts can be used and abused to threaten and to chill, but in other contexts, the law can have a protective function and can be used to send a message to shape and develop norms in more positive ways. And that includes protections for intimate privacy, for intimate expression, and those kinds of privacy protections can help promote more engagement in intimate expression. But it's not just the law. I think part of what Brenda's great contribution and her work shows, and I think thinking about her work in light of what I talk about in in the book, is that when powerful institutions are the ones making these decisions, we end up with blunt laws and blunt forms of surveillance and weaponization of these blunt instruments that disrupts all of these processes and disrupts more positive shaping of norms within society. I think part of how my theory can assist in this process is that once we see the dangers of these threats and their negative chill, we can constrain them through the roadmap and some of the reforms that I talk about later in the book. And then that opens the door for a greater participatory role from civil society. So civil society groups, activists, and scholars, great scholars like Brenda and Danielle, who are working in this context. And also thinking about Ari's work, who I draw on in the final sort of conclusion of the book, where I speak to how inevitably where this all leads, exactly as Brenda talks about, is a struggle over the norms. Because if chilling effect threats leads to conformity, it ends up chilling threats, right? And it ends up entrenching those norms. And so we not only need concrete reforms to constrain those threats, but we also need new ways of thinking about and shaping discourses of power to open up those new ways of experimenting so we can reshape those harmful norms that Brenda's work talks about. So thank you, Brenda, for that. And lastly, Damien, thank you so much for, first of all, willing to tune in so late. I see it's nighttime there, so very much appreciate it. And offering the European, putting on the hat of a European bureaucrat and how they would do things differently. And of course, I know I just have maybe just a minute here to respond. Again, I think certainly when we step back and do a comparative look, if we look at what's been happening in the United States in terms of regulation, certainly in my home country of Canada and other places around the world, the EU has been a leader when it comes to AI regulation, even the GDPR, which is, in my view, a deeply flawed statute. When I compare to what we have it at home in Canada and what's been happening in most jurisdictions in the United States, it's like night and day. So certainly the EU is a leader. At the same time, I think there's things that can be done differently along the lines of that I outline in the book. And part of my critique of the GDPR is that right at the core of its fabric, even from its initial recitals, its foundation is that it incorporates and integrates a lot of those key arguments based on innovation, the assumption that data needs to be accessed, right, for innovation, and that the GDPR provides a legal foundation for the kinds of collection and surveillance that leads to the problems, broader problems in society that my work sort of points to. So while, on the other hand, it aims to protect data, I think it also provides a legal basis for many of the problematic processes that I talk about in the book. So part of what I would do differently on the GDPR is thinking about fewer exceptions. I think also fewer surveillance cues. So one of the outcomes I think in my research is, cookies and notifications that say, is it okay if we collect this data about you, yay or nay? That shouldn't be left up to people. That's a surveillance cue. That's just going to lead to the kind of chilling effects that I mentioned in the book. On the AI Act, again, I think the EU has been, a leader. It's the most comprehensive piece of legislation. But my understanding is lately, through the process, it was earlier very robust and got weakened through the legislative process. And even now, there's this discussion that may be pulling back on some of its robust enforcement. I would hope the EU doesn't, and it moves forward in a robust way. The only thing I would suggest is we can have more of a conversation. I have other points to raise, but I'll stop there. But I really appreciate everyone's interjections here. I think we have maybe a minute or two for response, but I think we can also open up for audience questions as well.
Hi, this is Bridget. Sorry you can't see my face. For those I haven't met, I'm Regional Symposium editor. I wanted to pose some of the questions that were submitted in the registration form, and I'll try to combine where possible. So one question asks, countries in Europe are starting to ditch American platforms like Microsoft, Zoom, and Teams for more sovereign options. Do you think Canada can and should do the same? So I guess whoever wants to take this question.
I suppose as the resident Canadian, I should, have an opinion on this one.
At least you have less to fear about a tariff attack for saying things wrongly.
That's right. I'm wondering if there'll be new tariffs put in place following the symposium. I absolutely do think that Canada should implement more sovereign forms of data hosting. And so I think that's a natural outcome of both the politics and reality of what I talk about in the book, the privacy threats, the legal and regulatory threats. But I also have to say, given the Canadian experience with privacy and data protection, and one of the things I often mention at conferences is that absolutely no one follows Canada when it comes to privacy and data protection, and for good reason. We really have arcane and archaic existing data protection and privacy laws, which haven't been really properly updated now and we're going on several decades. And while there's, new legislation that are in the pipeline, there are problems still with it, including a pre-existing and continuing loophole that allows political parties to gather data with any kind of privacy constraints at all. Also, we had a recent attempt by the government, overreaching forms of lawful access. So while I do think it makes sense for Canada to take back some of its data and regulatory sovereignty on technology issues, so we can actually make these decisions. But it would help if we do so, we make those decisions and we take action. We haven't been doing it, and that's a big problem. But thanks for the question. It's a good one.
Thank you for that response. Another question that was posed asked, how can the global research community, so academics, journalists, policy advisors, convince more of the internet's platforms to make public, or at least available for researchers, the requests for suppression or removal that they receive? And I can try to put the question in the chat because I know that one was long.
Sure. I mean, I'm happy to jump on this, but of course I welcome any of my colleagues to also jump in. So how can the global research community, academics, journalists, and policy advisors convince more of the internet's platforms to make public, or at least available for researchers, the requests for suppression or removal that they receive? So that's a great question. I mean, one of the things that I can say is, and this is where Europe has actually taken a leadership role, and maybe Damien, you can add anything here if I get it wrong. But my understanding with the recent Digital Services Act, there is now a requirement, or there's a provision which allows for requests for this kind of data from platforms, and that access therefore is mandatory. We've had forms of transparency in the United States and Canada with the major platforms, and some of that transparency continues today, like, for example, with copyright removal notices. Google and other platforms have been transparent about these kinds of removal notices. But what I can say is over time, the hope with some of those early transparency efforts, which were largely voluntary and not done by law and not mandatory and not done by any kind of regulatory requirement, was that the transparency would extend to a broader array, and that's not the direction things have gone. In fact, over time, the platforms have been getting less transparent. They've allowed research having less access to API feeds and data. Others on this feed, like Nathan and others who work with this, can speak to this as well. That's also a huge problem. I don't know, Damien, if you have any thoughts on the European landscape on this account.
I mean, not largely beyond what you said, John. I mean, I guess the direct answer to the question is kind of what you said. I think you can require it. Yeah, you can put it in the legislation that they have to do these types of transparency reports. So, I mean, obviously there's, Europe has kind of been at the forefront in terms of moving in that direction. I think that there's a huge that's hugely beneficial in order to kind of understand, I suppose, the broader landscape in terms of the types of notices that are also being received from which jurisdictions. It paints a much broader picture. So it is, I suppose, a really necessary component of what is the Digital Services Act. Yeah, but it's a really good question.
Can I just add, we don't have to convince companies of anything. We have to convince lawmakers and agencies and courts to regulate and enforce laws and regulations. There's no need to beg companies to enforce or embed public values in their businesses.
I couldn't agree more, Brenda. I think the time for us to be sort of going cap in hand and asking for data and then getting cut off, I think that era really should be over. And it's an era where we should be making this mandatory in legislation. Of course, that's complicated in the United States. It's going to be done almost surely at the state level, probably looking to California being the place to experiment and be the leader on this, but I'll leave it there.
Professor Cohen and Professor Richards, do you have anything you'd like to add?
Plus one to what Brenda already said, right? There's not, we've gotten so accustomed to thinking that the companies just should only do what they can be convinced to do through a bunch of soft law and inadequate efforts at moral shaming. There's a perfectly serviceable template in an entirely different industry for much more comprehensive platform regulation, and it's the bank supervision model. Just saying, right?
All I would add, and I agree exactly with what people have been saying, is in addition to bank supervision, which I wholeheartedly endorse, and I think Julie do some really interesting work on this front. We have other models from within privacy law for the sorts of things we're talking about. I would only say that I think we're talking about maybe two issues here, and it might make sense to break them out, right? So one of them is a transparency against government requests, and I think we have a model for that which is quite good within privacy law, which is data breach notification law. And I think perhaps something like that, which every US state has and which was so good it caught on in Europe, sort of like David Hasselhoff, is to report various sorts of things that the government asks for. I think for the researchers, that's perhaps a little more complicated, but I think there are models and requirements, things like fair use or the Freedom of Information Acts might provide guidance. But I think in terms of the at least from my perspective as a theorist rather than empiricist, I think the government access, the government transparency is more important. That's easier to fix. The researcher one I think needs to be fixed, and I think companies are being deliberately opaque and using things like trade secrets as a guise for reasonable sharing. But I think that's maybe a harder question in terms of off-the-rack solutions.
Thank you all for your wonderful comments. We are going to move on to the next panel, but we really appreciate your contributions.
Thanks so much, guys.
Thank you.
Okay, we're going to move on to the second panel. Also, for all of you listening, all of these scholars and more will be contributing to a symposium issue in Vigil that's coming this summer. So you can read all of their comments soon. So our next professor is Professor Waldman. Professor Waldman is a professor of law and the director of the Center for Technology and Justice at the UC Irvine Law School. Professor Waldman is an internationally recognized academic, advocate, and is known in policy circles for his expertise at the intersection of law, technology, and society. Welcome, Professor Waldman.
Hi, everyone. Thanks so much for having me. It's a real pleasure to be here. Thanks, of course, first and foremost, go to John for what an incredible contribution and for inviting me to participate. I am honored to be part of this group. Thanks to Danielle for putting this together, Vijolt as well, and all of the panelists. I want to talk briefly about really three things, and I'll hope to get through it in 10 minutes. One is about John's theoretical contributions. Two is about John's methodological contributions, and three is about John. So I'm going to start, I'm going to go in reverse. I remember the first time, and of course, this is a scholarly publication. Vijolt is a scholarly publication. This is a scholarly symposium, but I don't want the author to get lost in that story. So John and I met years ago. I believe it was at an Internet Law Works in Progress conference. I think I was a PhD student, or I just finished my PhD, and John was presenting his chilling effects work. And I remember sitting there and thinking, wow, this is so amazing. Why didn't I think of that? And I didn't mean it in a selfish way. I was just so taken, so impressed with John as a scholar, and so impressed with the method. This was work using Google Analytics to identify when people were searching terms and so forth. And I was so impressed with the method, and I was so impressed with John's presentation and his close and nuanced ability to connect his data and his data analysis with larger conclusions about law, about the effects of certain things going on in society, and how people felt comfortable about searching terms and saying things and so forth. And since then, I have enjoyed and benefited from, and I hope John has benefited from, all of our interactions since. Every time I have a paper at PLSC, and I don't every year, but every time I have a paper at PLSC, I hope that John is there, because his questions are nuanced and his questions are so perfectly helpful and constructive for improving the project. So I see John as such a wonderful colleague, not just brilliant, but also a wonderful colleague, and someone that I hope I have helped and others have helped along the way as much as he helped us. So thank you to John for being such a wonderful friend and colleague. Two, about John's methods. So as a social scientist and a lawyer as well, I am always keen on looking at people's methods and learning from them, especially. And John is a master at taking what I guess we would call some form of computational social science and bringing it to make legal conclusions more nuanced. Again, so I have seen John at various points while workshopping, not just this book, but this whole research agenda, talk about the use of Google search terms, survey data, scraping information from available websites. The one thing, John may do this, but one thing that we haven't talked about is qualitative information, qualitative data. But John is such an expert in what he does that I find myself learning from it all the time. And I am triggered. I always think about, now every time I read John's work, I think about Ryan Calo in his new book, Law and Technology, a Methodological Approach, where he talks about how law professors and lawyers who do work in law and technology need a more refined method. And this book offers us a window into, or an opportunity to learn from social scientists and how we can learn more about the effects of law on society. And then finally, the third part, which jumps off directly from that. So John writes about chilling effects, and we've had a little bit of a conversation here about the differences between the positive chilling effects and negative chilling effects and potential positive chilling effects. And I don't know, I assume John intended this, but one of the big takeaways that I've gotten from his work is that chilling effects are features of life and law. They are not bugs. They're everywhere. And we know this intuitively. The mere prospect that a question could be asked has a chilling effect. Think about things like don't ask, don't tell, right? And that's before the question is even asked, let alone the chilling effect of actually asking a question. The mere possibility that a state can collect certain information has a chilling effect. So when Texas decided that it's going to investigate families who seek gender affirming care or even seek information about gender affirming care at a hospital that receives state funds, the mere prospect, even if they didn't actually collect information about it, the mere prospect that they could collect information and then potentially do something about it, push people to go to another state or push people to deny their children, push parents to deny their children access to the care that they need to live authentically and safely. The mere prospect that a phalanx of ICE agents and other federal agents will come to a city has certainly had an effect on how people interact with one another, the opportunity to engage in business and so forth. And we see this here in Orange County. Very purple Orange County has been the site of quite a few ICE surges and raids. And we have had, even when it's not, right, we see an effect on our Latino population here that is massive and incredibly important to the vibrancy of our community. We see less engagement, we see less commerce, we see fewer things that make Orange County what it is and make Southern California what it is. So these are mere prospects, right? And John's work, even though a lot of the examples that he talks about may speak to some of the negatives of chilling effects, John's work is, I think, pretty clear that these are emblematic of a phenomenon that is not a one-way ratchet that can go either way. Here are some really good examples of it to make it clear what the problems are. But I think one of his key contributions is that chilling effects are features that no matter what we do, there are going to be chilling effects. Some of them we want, some of them we don't want. And when we think about chilling effects that way, right, very different and a little bit broader than, say, how Justice Brennan used to talk about chilling effects in his majority opinions and then later dissents, I think we have a better way of approaching them. Danielle gives us a better way of approaching them in her work. And there are lots of other people who are working on the restrictions on people. I think a queer theory approach to laws related to sex would give us a really interesting, would add nuance and bring a really interesting way to apply some of John's theories. And, maybe that didn't enter into John's mind, but I think that there will be really wonderful opportunities for queer theorists, for feminist theorists, and others who are working on chilling effects affecting minoritized populations to apply what John has taught us. So I'm happy to talk more about some more details about all three of those things, particularly about John himself. But I'll pause here and pass on the torch to our next panelist.
Thank you so much, Professor Waldman. Professor Zittrain, are you able to speak now?
Yes. Sounds like
Okay.
a wedding kind of thing, or forever hold my peace, but I am here. Hi.
Let me give you a quick introduction and then we'll jump right into it. Professor Zittrain is the George Bemis Professor of International Law at Harvard Law School. He's also a professor of public policy at the Harvard John F. Kennedy School of Government, and he's a professor of computer science at the Harvard School of Engineering and Applied Sciences. Professor Zittrain is an internationally renowned expert whose work has defined the ethics and governance of AI, the regulation of digital property and cryptography, regulatory frameworks for platforms, and roles of intermediaries in our internet architecture. Thank you so much for making the time to join us.
Thanks so much, everybody. It's so great to see, if not the faces, talk about the power of norm and social conformity that I guess the norm for this session is all cameras off and less on the panel. But even just the names alone, it's so great to see so many familiar ones and indeed new ones brought together for the purpose. Hey, Danielle, thank you for popping up for a second. Brought together for such a well-earned festschrift of Jonathan's work here, and truly a book-length treatment of a topic that deserves the kind of kaleidoscopic set of approaches, John, that you've given it. And I apologize for not being here for the rest of the symposium. I'm at the National Constitution Center's retreat, which just happened to be double booked, and as you might guess, it's a time. But that feeds into the topic for today. And so with apologies if anything I say has already been said, I just want to echo Ari's appreciation of John's work and really encouraging the reader and us among them to be thinking about the dynamics here beyond the legalistic. And when you read and have framed the stories of Derek Ingram or Mahmoud Khalil, it really brings home some of the more explicit ways in which government power, backed up by corporate power, can be brought to bear to try to generate a conformity before it has been, whatever this would mean, organically achieved without undue pressure. And I also appreciate the ways in which John is urging us not to fall victim to status quoism. A lot of these effects, because of their subtlety, as you point out, John, might make it seem like the status quo on the surface. We all get used to this, but there's so much more power being brought to bear underneath that too quickly just becomes part of the scenery. And a lot of it is devoted towards preventing the formation and comparison of notes among people so that they can say, gosh, is it just me or ... And thinking about ways in which we might help understand and resolve our pluralistic ignorance within groups and as a polity and frankly as a country seems really important. And it may require reaching back to the sum of the naivete of the early internet days when we thought, our good old friend John Perry Barlow, that we could create a new global civilization of the mind by being able to communicate without interruption among everybody. Figuring out how we might do that in these times, and when I see what's happening in places like Minnesota and the uses of instrumentalities like Signal to create groups where people can just compare notes. Is it just me or seems really valuable. I also appreciate the double-sidedness of when social norms are bad and when they're good. Ari, you just made reference to this. If there are no social norms because, gosh, everybody should just go wherever they're at first, where you're at is going to be a function of the world you marinate within. So figuring out what the atomic me, independent of the world, thinks is maybe a fool's errand to begin with. And I get the Sharif experiment you talked about where people were given questions with no answers. And in a group, they all converge on a wrong answer and stick to it, but they are appropriately confused when they're left alone. I do think there are times when we are relying on norm to cabin behavior. And I don't know if that's the behavior of the powerful, and there should be chilling effects on them in the sense of, if I do this, maybe there's not a rule against it, but how will history look at me? How will my neighbors look at me? You know, when you've got nothing left in your quiver, norms is where you turn. And so thinking about what are the mechanisms to prevent undue Stepford conformity, but permit the function of social norm shame hypocrisy so that there is a debt paid from vice to virtue? That feels to me like a really important question. And finally, I think about, you mentioned in your book, John, the Hawthorne effect and the way in which panoptical surveillance can, if you're a worker, make you more productive because people are going to see if you try to catch that break you shouldn't catch. It does seem like a world in which people feel so monitored and feel that sanction will follow so predictably, right or wrong, but predictably, if they deviate from what's expected, it means that we can no longer know ourselves as to whether we are acting because we agree and it's right or because we just fear punishment. And that problem with perfect enforcement, which is taking the chilling effects frame to its, end point, really means, I don't know if it means we're going to get a purge someday where like one day the cameras fail and everybody's like, oh my God, what should I do? But how much more peaceful and self-governing a society, including one that has social norm within it, where there isn't a cop on every corner in every gathering, where there isn't immediate penalty ready if you break a rule, but given the system to allow for the breakage of rules where appropriate and not, murderous. And also to know if you follow the rules that you did it because you agree with them. Talk about pluralistic ignorance, where if we only follow the rules because sanction is so certain and swift, none of us knows whether the society we're a part of is actually emanating from us or simply we are its subjects. And all of these questions are raised by your work, John, and you've gone great lengths, not just to complain about the weather, but to do something about it. And so grateful for this opportunity to gather us together and, hope we can do it more often. I don't know how much Zoom is charging for this, but if it's at the moment less than nothing, we should do this more often. And thanks for the opportunity to weigh in.
Thank you so much, Professor Zittrain, for your time. Our next speaker is Carrie DeSalle. Carrie DeSalle is a staff attorney at the Knight First Amendment Institute in Columbia, and she's on the front line of critical litigation protecting fundamental freedoms, as in First and Fourth Amendment rights, against the chill of Trump administration actions. Ms. DeSalle, I
don't know if you can see me, but hopefully you can hear me.
Sorry. Okay.
Oh, you're muted. Sorry.
Oops. Better now?
Yes.
Okay, great. Well, thank you so much to VJolt for hosting the symposium, to Professor Penney for writing this book, on which I have already relied in my own litigation, and to the other panelists here for their incredibly important work on this topic. I have relied on much of your work as well. So as perhaps the lone lowly litigator in this group, I would like to talk about how Professor Penney's chilling effects scholarship informs my own chilling effects litigation. I started litigating cases centered on chilling effects back in 2017 when I first joined the Knight Institute, and shortly after the first Trump administration started pursuing its, quote, extreme vetting program in earnest. I'm not sure if folks recall, but in 2017, ICE was actively pursuing this program. It put out a call for proposals from technology companies seeking technology that would enable automated vetting of visa holders in the United States through review of social media and other publicly available information online. ICE wanted the program to generate the names of at least 10,000 individuals a year who would then be subject to visa denials and deportation. The technology companies told ICE, however, that they could not provide tools with the level of sophistication that ICE demanded at that time. So ICE hired human contractors instead to conduct that work. It was against this backdrop in May of 2019 that the State Department adopted new rules requiring visa applicants to disclose their social media handles on their visa application forms. Nearly 15 million people who apply for immigrant and non-immigrant visas each year are subject to this requirement, which demands disclosure of all handles they have used on 20 listed platforms in the preceding 5 years. Visa applicants' social media information is then indefinitely stored in government databases, including DHS databases, and it is also potentially shared widely among federal agencies as well as foreign governments. This enables both the retention of this information indefinitely and the long-term, and the wide dissemination create additional chilling effects on visa applicants' use of social media. The retention policies in particular enable the government to monitor visa applicants' online speech and associations not only before they enter the country, but long after they enter the United States. So we filed a lawsuit in December 2019 challenging these rules on First Amendment grounds as well as under the Administrative Procedure Act. Our First Amendment claim centered on the broad and, in some cases, quite deep chilling effects of these rules. We represented 2 independent international documentary film associations, one called Doc Society and the other called the International Documentary Association. These film organizations routinely collaborate with filmmakers and other partners from around the world. They rely on social media to communicate with their members and promote their work, as well as to research topics for new programs. On behalf of these plaintiffs, we explained in our lawsuit that the social media disclosure requirement chilled their foreign members' online speech and deterred foreign filmmakers from visiting the United States. Those chilling effects impeded the organization's ability to include foreign filmmakers in their US programs and to bring those filmmakers' work to US audiences. The biggest hurdle we faced at the outset of this litigation, as may come as no surprise to those of you who have read Professor Penney's work, and this book in particular, was establishing standing. Professor Penney has explained that the courts and the public more broadly have been quite skeptical about chilling effects stemming from surveillance alone, especially absent a specific threat of viewpoint-based visa denials lurking behind their surveillance. Of course, now the Trump administration is all about the viewpoint-based denial of visas and deportations lurking behind its surveillance regimes, but I'll get to that later. So at the time, we were confronted with the requirement that we establish an objectively reasonable chill. And the social science compiled in this book and discussed today will help us articulate why the chilling effects suffered by the plaintiffs in this case are objectively reasonable, not merely self-imposed. More directly, however, Professor Penney's insistence that there is nothing subjective or self-imposed about the surveillance itself would have been incredibly helpful to us at the time we were litigating this a motion to dismiss from the government back in 2020. And I think it's at this point that I first really relied on Professor Penney's work, specifically his post-Snowden disclosure Wikipedia study, this wonderful natural experiment that really demonstrated the objective chill resulting from surveillance. So we've also talked about, and Professor Penney addresses in his work, the kind of limits of privacy theories of chilling effects, and not to say that they're not incredibly helpful, but the, quote, nothing to hide sentiment really worked double time in this context because the State Department had instructed consular officers not to circumvent visa applicants' privacy protections at this particular point in the first Trump administration. So I'll note that this is in contrast to more recent requirements under the second Trump administration, where a number of different applicants for visas are required to make their social media accounts public to enable review. But at the time, if visa applicants were posting publicly on social media to begin with, the question was really, why shouldn't the government be able to search that speech? Despite compelling privacy and obscurity arguments, the idea that just because you're posting something publicly online doesn't mean that you expect it will be reviewed by anybody other than the 5 family members and friends that you may interact with on social media. Those arguments did not carry the day for us. So it's in this context, government surveillance, that I find Professor Penney's 4 chilling effects factors particularly helpful. So I just want to walk through those factors and explain how they directly relate to the claims we were making in this case. First, observation. The explicit purpose of the State Department rules was to enable surveillance of visa applicants' speech and associations on social media. Second, with respect to uncertainty, as to the speech or associations that might result in a visa denial now, and even more with respect to the speech or associations that might result in a visa denial or revocation or even deportation down the road, there was significant uncertainty. I'll note, for example, that at the time there was the story of an incoming Harvard freshman who was turned around at Logan Airport because of the likes of his friends on social media, and nothing he had said directly, and I believe nothing his friends had even said directly, just the posts with which they had engaged on social media. So there was a significant amount of uncertainty about just what kind of expressive activities, even if it's not your own speech, might result in immigration consequences for a particular applicant. And this uncertainty was exacerbated, again, by the indefinite retention policies that were already in place. Applicants might have a sense of what might offend this administration's sensibilities, the first Trump administration, but what about unknown future administrations? And the uncertainty was also exacerbated by the relatively vague dissemination policies that were already in place. Uncertainty as to the entities with whom applicants' social media information would be shared, potentially including foreign governments and potentially including repressive regimes in the applicants' home countries, in addition to other third parties. So the third factor, personalization. This one I puzzled over because this is a dragnet surveillance scheme. It's not a targeted surveillance scheme. However, I actually think this factor might be most significant in this context because here, not only were the applicants aware that the government was surveilling visa applicants' speech on social media generally, as envisioned in ICE's extreme vetting program that I referenced earlier, but here they were also aware that the government was surveilling their speech on social media specifically because they were forced to disclose their social media handles on their application forms. And I'll note that disclosure requirements are actually perhaps the one context in which the Roberts Court has given serious consideration to chilling effects, at least with respect to disclosure of charitable donors. Finally, power and authority. I mean, this is a given when the US government is demanding your social media handles so it can conduct surveillance of your speech on social media in connection with a decision about whether or not to allow you to enter or remain in this country. And one final point I want to make in the context of this case is that Professor Penney's conformity and compliance theory overall, I think, better fits with the chilling effects that many of the plaintiffs' members articulated to us when we were litigating this case. Some people stopped speaking on social media altogether or deleted their accounts. Others, however, were concerned that the government would draw adverse inferences from their absence from social media. And so they may have stopped speaking on social media about certain political topics, but they continued speaking about non-political topics, other cultural events and whatnot. And this reminded me of a kind of McCarthy era Hollywood. The industry did not stop making movies, but instead of movies like The Grapes of Wrath, it produced capitalism-friendly rom-coms and the like. So I don't want to take up too much time with further articulation of the very specific applications of Professor Penney's work to my own work. I'll just note that these requirements have been expanded under the current Trump administration. Just last week, OIRA approved a USCIS proposal to require applicants for many other kinds of immigration benefits, including green cards and naturalization, to disclose their social media handles on their applications. And it's currently reviewing a proposal by CBP to require ESTA applicants to disclose this information as well. Meanwhile, as I mentioned, the State Department has required applicants for FMJ and H-1B visas to set their social media accounts to public to enable review. And then this is putting aside all of the second Trump administration's much more heavy-handed, frankly, and now explicitly viewpoint-based ways in which it is wielding surveillance to punish speech. I think Professor Zittrain referenced Mahmoud Khalil. The Knight Institute has been litigating a case, AAUP v. Rubio, that has succeeded in convincing the court that the threat of deportation based on your political speech is a violation of the First Amendment. So I'll pause there, and thank you again.
Thank you so much, Carrie. We have our last speakers in the second panel, and we have two speakers who are going together. First, we have Professor Nathan Matias. He is an assistant professor at the Cornell University Departments of Communication and Information Science, and he is the director and founder of Citizens and Technology Lab, the CAT Lab. He's doing groundbreaking critical work on digital governance and behavioral change in groups and networks shaped by AI systems and citizen science. He will be speaking with Lucas Wright. Lucas Wright is a sixth-year PhD candidate in the Department of Communication at Cornell, specializing in the technological study of digital platforms and artificial intelligence. His research focuses on the intersection of online trust and safety and the impact of emerging technologies on civil liberties. Thank you for joining us today.
Thank you. And it's brave to let some social science round out the end of an excellent conversation. I'm going to try to share my screen, and hopefully that'll pull up. I think we're good for you to start, Lucas.
Okay, hello everyone. So as many of you probably know, in July of last year, President Trump signed an executive order on the government procurement of AI systems, requiring that government agencies vet AI systems for wokeness. In combination with other orders on AI and diversity, equity, and inclusion, the administration redefined AI bias as bias against conservative political ideology, rather than discrimination against people on the basis of race, gender, and other protected classes. In theory, these orders are about how the federal government acquires computer software, but as social scientists who have studied AI bias, we have also been wondering whether these orders might chill academic research on AI bias and discrimination, especially in combination with all of the widespread federal cuts to research that the administration deems woke. And as Alondra Nelson has said regarding to this approach to AI deregulation, governance is always governance of someone. When a graduate student loses funding for a scholarship on algorithmic bias, that is not an abstraction, it is AI policy in practice. So one of the things that John Penney's new book attempts to do is to bring legal doctrine and behavioral science together in a unified theory of chilling effects. And so as social scientists on the social science side of that unification, we think that this book can help us think through how we would develop new ways to measure chilling effects as conformity and the unique measurement challenges we might face in doing so in an example like what we just talked about with AI bias. So first, Lauren already did a very good job of introducing us, but just to reiterate, my name is Lucas Wright. For those of you who don't know me, I'm a PhD candidate at Cornell, on the verge of defending my dissertation in less than 2 months. So that does mean I'm on the job market. And along with Nathan here and John Penney as well, we've been working for years on a study of the chilling effects of automated copyright enforcement online. And as Lauren said, I've also conducted related research on automated content moderation and online trust and safety startups.
And I've been just so grateful over the years to have a chance to collaborate with John and be conversation partners ever since we were grad students in the mid-2010s, talking about ways to bridge behavioral science and the law. I get to do some of that work at the Citizens and Technology Lab, and we've been so grateful over the years to have John as an active conversation partner in many of the things that we do. So how do social scientists typically think about chilling effects? We want to give you a map of what this book means for us. In the classic model, people have a base rate of engagement in protected speech, such as social media posts per day. And there's some interruption of a government action, which causes people to update how they think about risk and reduce protected activities compared to what they would have done otherwise. Instead of going up, the orange line goes from increasing to decreasing or reduces in some way. This is a powerful model, and John has done important work to validate this theory in the work on Wikipedia that folks have already referenced.
Okay, so thinking back to the example that I opened with AI bias and federal policy, this classic model would likely say that what we are looking for in a chilling effect with AI bias is a reduction in people's speech or academic speech about AI bias. But unlike this classic model, John's new theory does not necessarily predict a reduction in the overall volume of speech. And that's really useful in this example because AI research is incredibly trendy right now. And so even with the negative pressure from the administration, we might not expect a reduction in the rate of growth in AI bias research right now. And just quickly looking into this the other day, Nathan and I found that in a search of papers that mentioned both AI and bias, 2025 was a huge year, much bigger than previous years, as you can see in that graph. And so the classic model would look at this graph and say, there's no chilling effect here. People are still speaking about AI bias. But John helps us to see how conformity might also represent a chill. So the administration offered their own definition of AI bias, which is anti-conservative bias in these models. And like Alondra Nelson argued in the previous quote, conformity is the government's mechanism for setting policy here. So she says in that same piece that norm entrepreneurship, the work of establishing collective understanding about appropriate behavior, shapes what is possible before any rule is written. And so drawing on John's work, if we wanted to answer this question of whether the Trump administration is having a chilling effect on science, we might measure qualitative changes in AI bias research that is getting published to measure this chill, rather than just the overall volumes in how much people are publishing about AI bias. We would also potentially look at different outcome variables, right? So instead of just looking at individual changes in behavior, we might look at collective chilling. So how could we do this in practice? And in this case of AI bias research, we might measure changes in entire fields and institutions, like university research policies, attendance at conferences, the career trajectories of AI bias researchers, rather than only considering changes in the publication rates of individuals. These collective outcomes are especially important in academia, as many of you know. Scientists who are not chilled by the government and would continue to research AI bias and discrimination might find that collective shifts in behavior leave them with no conferences to present at, no secure job prospects, and fewer similar papers to cite and build on in their own research.
A third idea we want to discuss is this notion of the additive effects of chill, coined by Nadler, which imagines chilling effects as examples of cumulative exposure rather than big shocks. It's kind of similar to pollution exposure or exposure to things like cigarette smoke or other poisons, where each action by a government, corporation, or hateful groups updates a person's assessment of risk until a person crosses a threshold that causes conformity. In the case of AI bias, the DEI executive order in January, later dropped, would be one dose. Cuts to AI grants that mentioned DEI in April might be another dose. An executive order about woke AI in July, again. Immigration restrictions by the State Department in December could be another dose. And depending on someone's risk tolerance, they might well change their research direction or alter how they write about something as exposure adds up. The additive model has the advantage of greater fidelity to human behavior and what we know about humans, but it also has a trade-off. Just like all abstractions, the more true to life it becomes, the harder it is to measure and model and explain. For example, by accounting for differences in people's risk tolerance and thresholds and the level of exposure, the additive model is actually exponentially more complex than the classic model of chill.
So we're both really excited that John's book brings legal doctrine into a closer harmony with current findings in communication, social psychology, and behavioral science. That is very, very, very much needed. And it helps us understand things like attempts in the United States to cut and to influence the direction of AI research, and many other issues as well, most likely in a way that I think the classic model doesn't give us the language to talk about in terms of chilling effects. And so we're excited by the opportunities that this will enable for future collaboration between science and the law. And at the same time, the types of chilling effects we've described here are very complex, and measuring them will require innovation in social science methods. As Nathan just alluded to, complexity can enable models that get closer to actual human behavior, but with results that are harder to clearly explain. And so one thing that we are anticipating moving forward as we look to build on John's work here, is that finding the balance between complexity and explainability will be essential for a conformity theory of chilling effects to gain prominence across all of these many different fields.
And then finally, as a citizen science and action research lab, we wouldn't want to end without noting something that John's work has inspired and is also shaping and informing, which is a project that we're developing with John, the Knight First Amendment Institute, and a growing team called STAND. The Science and Technology Advisors Network is working to advance basic science, connect litigators with experts, and grow links between legal doctrine and science. We're so grateful to Professor Penney for more than a decade of work to do this bridging work, and in fact, many of the people in this room. And we're eager to work together to see the conversation continue to advance theory and also move from theory to practice. Thank you.
Thank you so much for your wonderful contributions. Just like last time, I'm going to put all of the panelists together. And I'll let Professor Penney reflect.
Great. Thanks so much. And once again, it's just really an honor to have such a fantastic and wonderful lineup of brilliant scholars who, and mentors who've really shaped my thinking, shaped the book. And as I'll explain in some instances, really the book in literal sense would not be possible without them. I'll start, of course, with Ari starting off the top. And I definitely remember that moment that we met in that workshop that was Internet Work in Progress, I believe at Santa Clara, back in, I think 2013, actually. No, sorry, not 2013, would have been the following year. I think so, anyhow. Or maybe even later than that, I have to think about it. But I remember there was also a lawyer from Wikimedia Foundation there who, seeing the findings, said, hey, we've got something in the works. This is going to be really helpful for, just wait for it. Turns out later they launched a lawsuit against the NSA and the US government. I ended up later acting as an expert for the ACLU and Wikimedia Foundation. And so certainly remember that. And I remember our conversations then. And I can easily attest that I've learned so much from our conversations over the years, and I really appreciate you being here. Like Brenda's earlier framing, I really loved your framing here as well. Thinking about it, I think that's certainly what my book aims to do. And I can see it in some of the contributions from Julie, from Brenda, and of course, then thinking back, as you mentioned, thinking about Danielle's work in this context, Marianne Frank's work in this context, when we think about chilling effects and these impacts in conformity and the impacts on people and broader society, it's not just a zero-sum game. It's not the way we need to think about a conventional understanding. That is, it's inherently a negative. We lose only speech, and then we're directed only to a legalistic finding of the First Amendment, and we end up going to court. That's the old understanding of this. And really what I want to get across in the book is a far more complex and nuanced understanding of these in a range of contexts. And from one angle of view, you might say, if John's thinking and writing about chilling effects, when you think of that, the conventional understanding is you think of the chill of laws or legal threats. And so how would his work fit with that of Danielle and Marianne Frank's? Well, it fits quite perfectly, to the extent that one of my key arguments in the book is that the privileging within the law and conventional understanding of legal and regulatory chill, which regularly leads to forms of, First Amendment injury, and has been used to gut a lot of positive forms of laws and regulations over time. That has been privileged in other kinds of chilling effects and impacts and conformity effects due to surveillance, due to forms of abuse and personal harassment. The kinds of things that Danielle and yourself and Marianne Franks and others have written about and talked about so compellingly that I've learned about. My work has aimed to assist in that conversation and support those efforts too. And so I really appreciate that framing. And I think it's absolutely bang on. Jonathan, it's fantastic to see you. And one of the things that I would, speaking of great mentors, like Danielle and Neil Richards and people who've really shaped my thinking over time. And Jonathan is certainly another who has supported my work for such a long time. In fact, I can say in sort of a literal sense, I first met Jonathan when I was a low sort of graduate student studying law at Oxford. And I went to see Jonathan, who was then giving his lectures at which I wasn't even aware of, this department, Oxford Internet Institute at Oxford, on the future of the internet and how to stop it, which would later become his book. And it was really those lectures which first inspired me to first think about data and think about sort of like broadening my horizons beyond the law and understanding it. And secondly, returning to the OII, which I would do years later to start a doctorate. And so certainly this project, the doctoral research in the book based on it, would not have been possible if not for that sort of early influence from Jonathan. So what he mentioned again, some fantastic framing here. On the one hand, the importance of shifting norms and you evoking John Perry Barlow. And that seems to be a common theme amongst some of the interventions with respect to the book, that once we sweep aside and we constrain some of the powerful abusive actors that are using and abusing these threats, we can start getting back to shifting the norms in more positive ways. And how do we do that? And that's Ari's work, that's Brenda's work, that's Danielle's work, but I think you've also raised it in an original way in invoking John Perry Barlow, which is really, yes, getting back to like building a better society. And in some cases, like you mentioned in Minneapolis, using technology to that extent. But it's also thinking of ways about more traditional instruments, be it law, be it activism, that we can push things in a more positive direction. And lastly, that you mentioned the Hawthorne effect, absolutely. And I know, you're in the book, which helped shape my thinking on perfect enforcement, which you talked about in the future of the internet, how to stop it. And hence my chapter 10 is named The Future of Chilling Effects and How to Stop It, obviously an ode to your work in that sense. And perfect enforcement, exactly what I've been thinking of when I talk about this notion of supervillains and these new systems that combine AI, facial recognition technology, and near perfect forms of personalized enforcement, where we're so chilled by these systems, which you might say are the future, but they really are here and now. It's hard to tell the difference when we're chilled and where the directive is such a clear and perfect enforcement regime where we have no choice whatsoever. And so that we end up with what Julie had mentioned, there's really no escape. And I think the aim here is, my concern is heading off that future with some of what I talk about in that last chapter, key reforms along those lines. But yeah, I think it's building the better society and shaping the norms in a new direction is the key that I really want this new understanding to go in. So thank you so much for that. Carrie, it's an honor to have you as well. Carrie, you're really at the vanguard of major litigation tackling these issues with different governments, but of course the US government. And one of the things that's come from my conversations with Carrie and different conversations like this, webinars that we've done together, like at Columbia Knight First Amendment Institute, is how impressed I've been with the empirical work that Carrie's team has been doing in documenting chilling effects in creative and innovative and original ways. And I'm just so thrilled that my work has supported what you're doing and has made your work easier, because I know your work is incredibly hard and incredibly complex. And of course, I think all I would leave to say is I'm looking forward to helping you in whatever way you can and where these conversations going forward. So thanks for being here, and really thank you for your work. And lastly, Nathan and Lucas, again, it's so great to have such fantastic colleagues and collaborators and friends. Yes, Nathan, we go back a long ways as well, and we've been collaborating for a long time. And one of the things I love about your intervention here is, thinking about some of what I talk about in the later parts of the book. I'm saying, I'm sort of like cheering myself to, yes, someone's getting the AI safety implications of part of what I'm talking, whether it's talking about bias, talking about how all of this leads to sort of different collapses to the mean when it comes to these systems and the processes themselves and underlying it, but also their impact on society and how they shape us on a societal and individual level. And of course, I think the framing is quite right, and I love what Lucas said there at the end. It's great to have Lucas here, and yeah, you're going in the job market, but I think you'll be just fine, given what I know with the fantastic work you're doing, bringing law closer to social science, which really is a key aim of this work. Both thinking about chilling effects research and theory almost as its own field unto itself, similar to how David Lyon did with surveillance studies. I think there is that growing body of work. And I think what you're doing and what you've been doing at the CAT Lab and what I aim to do with this book is exactly that, to break down those barriers, work towards better, more insightful, methodological, interdisciplinary collaborations. And that's where we're going to get those insights that will continue the fight that already Jonathan mentioned, Brenda and Daniel's work all point us to. One thing I would mention is I cite some different European scholars in the book, actually, that I think can be helpful in exactly this, like thinking about exactly this threshold analysis of risk and the additive effects that you mentioned. Michael Latzker's group at the University of Zurich and a few other European scholars have been looking at this in the sort of ubiquitous cellular context, and they've been really doing a lot of great research documenting chill, the impact of data valence in that context that I think could inform what you're doing. But I think I'll leave it there. I know we want to leave some time also for Q&A, and of course invite any one of any of the speakers who want to reply to anything that I had to say there.
So hi again, this is Bridget. Again, apologize that I'm off camera. I'm in the viewing room at UVA. But we did get some questions submitted in the registration form that I wanted to pose to you all. So one question that we got was that how should we navigate the fear of retribution some may experience on the internet that prevents them from engaging or researching potentially controversial topics? So whoever wants to.
Sorry. Yeah, I mean, I can jump in, but of course, I won't occupy the whole time. I'm sure Nathan will have something to say about this as well, and others. I mean, part of I think why my Wikipedia study resonated and got so much attention at the time was given the scale of the impacts, this idea that mass government surveillance and often the response that we would have to these kinds of processes would be to shrug, and that this is just going to be normalized and that everything's just going to go back to normal. And this will be just the new norm, the new standard, and everyone will accept it. And I think part of what's different about those findings is that it shows that there really wasn't that quick return to the norm. In fact, you've got this baseline that shifts over time, where the chill or the impact on people's willingness to access sensitive topics, sensitive content, really reduced over time as the information rollout and greater awareness of the known and revelations rolled out over time. And I take a few things from that. One is, I mean, just to keep in mind the scale of that data set, the views of the Wikipedia articles that I collected in that set were upwards 80 million views. So we're talking a lot of people that were captured in that data set. But secondly, that's just one site and one place on the internet that you would be willing to search for information. And a lot of those topics are pretty benign. You would assume that whatever's on Wikipedia is pretty acceptable, very mainstream. You can only imagine inferring from those findings and from findings other researchers who corroborated my findings in other contexts. You would imagine that in other areas where you're doing research on more sensitive more explosive, more privacy sensitive contexts, it's going to chill that research and the insights we get out of it too. So researchers are affected, citizens are affected, everyone's affected. And then that's part of the broader challenge of the added effects as Nathan raised. If anyone else wants to jump in.
So all I'll say is that there are definitely going to be differences. I assume the question is about the researchers themselves. When you say what can we do, you mean about what researchers themselves do as opposed to what society can do or law can do to protect them. If we're going to be in a position where we're putting the onus of protection on the self, right? That's kind of what we do in this country is we tell people that, you're going to have systems that are going to oppress you and you have to do your best to protect yourself in those situations. That's what we do pretty much to anyone who's been harassed online, as well as John and others have talked about. But when it comes to researchers, not everyone can do that. That's part of the problem. But we also have built in a system in academia where in some ways our hierarchy, senior scholar, junior scholar, whatever, in some ways that imposed hierarchy creates problems for the university system and for faculty governance and just collegiality. In other ways, it provides an opportunity for people who are more senior to step up and provide the protection that scholars who are both younger and represent minoritized groups need in this environment. And it's not enough for senior scholars, and I consider mid-levels as well, it's not enough for people with tenure to just go about their business. It's incumbent upon us to use the power that we have through our university's commitment to academic freedom to maintain research on these areas that the government doesn't want us to research on. If we don't do that, then what's the point of academic freedom in the first place?
Thanks.
I guess I'll pose one last question that was also asked in the registration form, but thank you all for your comments. So this question asks, how can we protect the rights of marginalized groups, activists, and other groups who may suffer from the impact of surveillance and these chilling effects? And I think you sort of touched a little bit on that, Professor Wolpen, but other thoughts?
I'm sorry, can you say that again? I don't know if anyone else, but it just broke down, muted out for a second.
Just appeared in the chat room.
I put it in the chat, but I can definitely repeat it.
Okay.
So how
Thank you. No, it's fine if you put it in the chat. Yeah, sorry about that.
No problem.
I mean, it's interesting because that seems as much a question about persuasion and salience to the public at large or to people in a position to change the dynamics here than about just analytic rigor. And I can't help but think that whenever we're presented with a configuration of somebody doing something to someone else, we immediately instinctively place ourselves somewhere in the frame. Are we the victim? Are we the perpetrator? Boy, if everybody's using Signal, are they going to hatch a rebellion and I'm going to lose? That's why we need law and order. And trying to figure out how to tell a sufficiently universalist story, a la the famed, even I dare say now trite poem about First They Came For, to say, you may not think this concerns you, but you are tomorrow's marginalized group or marginalized person. The whole point of this, especially given the granularity afforded by the technology, is that wherever you choose to step off the path, whether you are a discrete and insular minority, you could be in trouble. So unless you truly want to live in a Stepford world, this is why you should care. And I feel like trying to come up with illustrations that create a new majority of those who are not conforming at one time or another is probably the way rhetorically to do that.
I would just add a legal wrinkle here, which is And this is part of the problem with chilling effects doctrine in general, which is that when people are chilled from speaking, for example, they might, given government surveillance or what have you, they're probably going to be chilled from making those claims in a lawsuit that's publicly available online and directly attacks the government. And on the flip side of that, the people who are in a position to come forward and raise those chilling effects claims, the courts might view them as less chilled because they have been willing to put themselves forward. So it creates real difficulty in litigating these cases, when you don't have the kinds of courageous faculty members, for example, that came forward in the AAUP v. Rubio litigation that I mentioned.
Yeah, I mean, I really couldn't put it any better than I think Jonathan raising the rhetorical point and Kira raising. Ari, did you have anything you wanted to add? Okay, thanks so much, everyone.
So thank you everyone for your participation in the symposium. It has been really wonderful. We are going to wrap it up. I'm going to hand it over to Professor Citrin for a few remarks and then to Professor Penney. But thank you again. This has been such a lovely conversation with so many various perspectives. Again, for those in the audience, all of these scholars and more will be contributing to the JOLT symposium issue. So you'll be able to read a little bit more about their perspectives and how Professor Penney's book affects their work.
Okay, perfect. So I think as our wonderful panelists made clear, John, your work has been so generative of ideas, of interdisciplinary methodological work that we've built on the work that you've done, and together, so many of us have joined you and you spawned a whole set of other questions that you've helped develop from your formative study, that incredible study from 2016. Now it has created so many new pathways for proof that I hope, Carrie, in your work. I imagine what John and Alexis and I have done, we always hope is helpful to you in litigation, that we can make cognizable harms, and either for standing or for elements of causes of action that are often viewed as it's no big deal. You have to just suck it up and so deal with the kind of abuse and silencing that we have seen. And conformity, as you noted, who can step up are often those who can, and so we dismiss it. And so it's been incredibly gratifying to seeing, this web of friendships, and the folks on the call that John, you've been part of this wonderful web. So I have to say, forgive me, Jay-Z. So Jonathan Zittrain, we did a symposium of concurring opinions for your brilliant book, The Future of the Internet and How to Stop It. And I feel like I was once a young law professor meeting Jay-Z in 2007 at a conference, and he sort of, said, "You got this, kid. You're part of the club." And I think, John, you've done that for many others. And so, Alexis, I see our partner in research, Alexis Shore-Ingber, who you, John, brought together with us. And now, so for Lucas, who I know is concerned about, I'm not worried about you in the job market, but just to say, when we met Alexis as a grad student at BU, she's now a professor at Syracuse's brilliant Newhouse School. So I'm so excited to have this community together and see my partners in this work. And Ari, I'm looking at you. But for all of us as a community, John, it's amazing to come together around your brilliant book. I've read it now 3 times. I feel honored each time that I've read it. And so I'm going to hand the mic over to you, but just to say thank you for this work, for bringing us all along in the work that we have done, as you've been doing this work, and gratitude for everyone who's joined us, and to VJOLT. We so appreciate you, Lauren and Bridget, for doing this. So now I hand this over to my dear friend, colleague, and co-author, John.
Thank you so much, Danielle. And of course, this is going to be the moment where I begin, a range of profuse thank yous, which, I will begin first and foremost with Lauren and Bridget, and of course the entire team at VJolt for, all of the time and effort they put into planning, organizing, coordinating, and then of course today hosting and pulling off just flawlessly this fantastic symposium, and of course the work that will be coming and their willingness to edit this special issue that will be published by VJolt in the future. I just cannot thank them enough. I cannot say better things about the time they put in and how they put up with me being, time slow in my responses, and it's been just fantastic working with them and putting this on, and I really thank them so much. Of course, I have to thank also Danielle, who, as she mentioned at the outset, really was the original mover and conceived the idea of the symposium dedicated to the book and pitched it to Lauren and Bridget. You've been such a fantastic supporter and mentor for me and my work. And, I'm thrilled that we've had a chance to work together, and, I hope we continue that. Of course, this is sort of the dream, right? As a scholar, you write a book, that you have a group like this of incredible, eminent scholars, people who have shaped my thinking, and mentors like Danielle Neil Richards, who was one of the original sort of peer reviewers of the book, and who's really shaped my thinking, but also shaped and mentored me as a person. I'm so thankful, and Jonathon and many others here. This is the dream, right? You read a book, you have this wonderful group of people reading it, using it for their own work, whether it's litigation with Carrie, it's new paths of new direction, thinking about sort of collective AI like Nathan and Lucas's work, or Brenda and Danielle working in intimate privacy. It's just so brilliant to see, and I just thank you all for being here. This has been incredible for me. And I thank you all so much. Thank you for taking the time. I know you're all so busy, and I very much appreciate it. I'm looking forward to the published special issue. Thank you all so much.
Thank you, everyone, and we will be circulating a recording after this as well.